Good afternoon, participants. I'm Yashwendra Singh, Executive Editor of ETCIO, and I welcome you all in this extremely topical webinar on how to realize your US immigration dream. India is now the biggest market for the United States employment based immigration investor visa program, EB5. However, will it continue to remain so? Needs to be seen. I am saying this against the backdrop of the Department of Homeland Security announcing new regulations for EB5. To start with, EB5 investment will be raised by 80%, up from 1 million US dollars to 1.8 million US dollars, effective 21st November 2019, in a US project that will cater to at least 10 jobs in order for EB5 investor to apply for a green card. The green card, as we all know, allows a foreign national to live and work permanently in the US. For TEA or Targeted Employment Area project, the investment will be increased from 500,000 US dollars to 900,000 US dollars. The investment amount will be adjusted to inflation every 5 years. The TEA eligibility, which was previously determined by the state, will now be determined by the DHS. Recently, the US House of Representatives passed a bill removing the cap on issuing green cards. This will increase green cards issued from the current limit of 7% per country per year to 15% per country per year. Against this backdrop, we have with us Mr. Pankaj Joshi, Managing Director of Nysa Global, a leader in the EB5 practice, who will throw light on what the new regulations mean for those looking at US immigration and how they can smoothly achieve their goal. Mr. Pankaj Joshi founded the firm in 2010 and has led the investment immigration practice since 2012, having worked with investment selection and analysis, securities documentation, and client immigration documentation. He's a strategic advisor to families and high net worth individuals looking to expand their global footprints for personal and financial growth, working with them to navigate the complexities of global migration through investments, international business investments, and expansion and pre immigration tax planning and structuring. Today's session gains even more importance because a potential EB5 investor who is looking to migrate to the US has only 3 months window to act on the new regulations. So without any more delay, I would request Mr. Pankaj to deliver his presentation. Over to you.
Thank you. And good afternoon and welcome to the webinar on EB5. I thank the Economic Times Group for organizing this webinar, and I welcome you all to our presentation. I'm going to run this presentation in 4 parts. I'm going to start by an introduction to the EB5 program, followed by what are the key challenges that are being faced by the Indian community as they plan or have done EB5 in the recent times. I'm going to follow this up with a little bit of an introduction or a little bit of chat about these changes that are forthcoming and what they would mean for people that are planning to invest and for those that have invested recently into the EB5 program and are still waiting in the process. And I'm going to follow that up with the last part, which is on how to understand how, or just to sort of our feedback on how to select an EB5 investment, how to make that decision, and how to choose or listen between the noise that is there in EB5 today. So I'm going to start to share a screen with you, which is just going to be a quick walkthrough on what is the EB5 program for those that are tuned in and are here to learn a little bit about the EB5 program. Okay, so are we on screen share? All right. So the EB5 program, as you know, is the employment-based fifth preference program in the United States. There are 5 employment-based programs that the US government or the US migration has allowed. This is the 5th one, and this is an investment immigration program that they introduced. The program was introduced in 1990 with the objective of promoting economic development in the United States and creation of American jobs. The backdrop to the introduction of this program was that similar programs were being introduced in Canada and certain other countries, where these countries were inviting foreigners under various schemes that they had. Some were real estate related, some were government bond investment related, that gave the investors permanent residency or passports in those countries. The US wanted to came up with a program which was slightly different. They said this is going to be an economic investment, a foreign direct investment into a new business in America, and the business must create American jobs. Uh, the program had basically two categories. What they said was if your investment is located in what is called a targeted employment area, which is defined as a census tract, which has a with an unemployment rate of about 1.5 times the national average or above, the investment amount was set at $500,000. Um, if your project was not in what is called a targeted employment area, the investment amount was set at $1 million. It was also set that every investor's investment must lead to the creation of 10 American jobs. Um, Now, what they also did further to this is that they further divided the type of investment that you could do into two categories. The first is called a direct investment. A direct investment is when you, as an investor, go set up your own business in the United States that you own and operate. This required, again, the investment could be $500,000 or $1 million depending on the location of the project, and also it required you to create 10 full-time American jobs. In 1992, they introduced what is popularly called now the Regional Center Program, where essentially what they envisioned was there would be a larger project that will be able to take in multiple EB5 investors. And this investment, if it was located in a TEA, would be $500,000 and $1 million if not in a TAA. But what more importantly they allowed was what is called an economic impact of such a project. So what they said was that if there's a larger project, there is an economic multiplier effect of such a project. And they allowed and prescribed an econometric formula which calculated the number of jobs resulting from this project's actual creation, which included not just direct jobs, but also indirect jobs and induced jobs. So effectively, a project which is under a regional center or sponsored under a regional center leads to the creation of far larger number of jobs than what is a direct investment, because there they only count direct jobs. The beneficiaries of such an investment would be the investor, spouse, and all unmarried children under the age of 21 at the time of filing of an application. Okay. So now, what is the EB5 program and and how it works? The EB5 program really has two simple requirements, right? You as an investor have to qualify, and your investment has to qualify. When you talk about the majority of the EB5 that happens today, and I mean more than 99% of it, it goes into what are called project investments under the regional center program. Therefore, the projects are already pre-qualified and are pre-structured to meet the requirements of EB5. So in majority of the EB5 projects that are available out there, it is pre-qualified for success as an EB5 project. So really the primary thing that you need to do is qualify the investor or the investor's family for the EB5 program. There are two parts of the documentation. There is the personal qualification, which are mostly biometrics, like passports, date of birth, certificates, marriage certificates, and the fact that you don't have a criminal record. But the most important emphasis that the US places is on what is called sources of funds, is that you have to be able to identify clearly where that the investment amount has been earned by you from legal sources and lawful activities. Okay, and we can get into the documentation of sources of funds, but essentially it can range. The money does not need to necessarily come directly out of India. It can come from anywhere in the world. It could be employment based, it could be an asset sale based, it could be business income. As long as you're able to demonstrate where you earned the money and justify the sources of the income, you will qualify for the EB5. We will now just talk a little bit about the process of EB5. EB5, sounds very easy. You make an investment and you get green cards. But there are many slips between the cup and the lip in this process, and it is very important for people to realize various steps that are in the EB5 process, and therefore the expected timelines of of the various steps. The process starts by your selection of an EB5 project. At the time of the selection, you basically, once you've identified where you're putting in the money, you also start engage an immigration attorney who helps you organize your documentation for your filing. Once these documents are prepared and your file is ready, your investment amount is deposited into an account in the United States along with the relevant fees, etc., that go with it, and your petition is filed with the United States Citizenship and Immigration Services. Upon filing of this petition, which is called the I-526 petition, in a few weeks thereafter, the USCIS issues a receipt along with a filing number and what is called the priority date or the date of your application. The priority date is very important for your future processing of your EB5 application, as we will come to talk about later, and what that means as in countries that are backlogged and this process is now taking longer than before. Once this application is filed, the next step is an adjudication, which hopefully should result in an approval if your documentation and project have been qualified properly. This typical approval time could be between 18 to 24 months. When we started working in the program, our initial projects in 2013 and 14, we used to get approvals in about 6 to 12 months. But as the number of EB5 applications have increased in the system, the processing time has slowed down at USCIS. But you should at least budget about an 18 to 24 month cycle for the adjudication of an EB5 application. Once an application is adjudicated, there are basically two possibilities for the next step. The next step after an adjudication is the issuance of a green card or your filing for the actual green card. There are two possibilities. Either the applicant and the family are located within the US, whether it is in the name of a child that is on a student visa or on a work permit in the United States. As long as they're legally in the United States, you apply for what is called the adjustment of status. This is a three-step process. Once the adjustment of status is filed, you're initially issued what is called an employment authorization card. This typically will take you 60 to 90 days after the application is filed to receive. The employment authorization card essentially overrules all your other non-immigrant visas, and you are thereafter authorized to work and live in the United States and travel internationally as you await the green card to be issued to you. Now, for the issuance of the green card, there are two steps that the US Migration Department follows. One is a medical test. So there will be a medical center in the United States that you and the family members will have to go for adjudication, for a medical test and qualification. The next is a legal test, which the US Migration Departments run. They do a background check of your stay in the US since the time you've been there. This could take anywhere between 3 to another 9 months. So expect that from the time that you file your adjustment of status to getting the EAD card, which essentially allows you to do everything that a green card does, which will come in about 3 months, but the green card will take 6 to 12 months after the adjustment of status filing is done. Now, the other way is that you are not in the US and you're actually outside. You're living in Delhi or Mumbai or anywhere outside the United States. Then you apply for what is called the consulate process. The consulate process is where you file with the National Visa Center and they give you an appointment at the nearest consulate that processes EB5 migration applications. Presently in India, the center is in Mumbai. We have seen in the past that the appointments used to be also in Delhi, but we've not been seeing any appointments coming to Delhi of late. Once you show up for the consulate appointment, you have to take with you a medical test report. There is a medical center that is appointed by the US Migration Department where you go for your medical tests. You also have to take a police clearance certificate, which is issued by the local police station or from the visa office, which essentially shows that you have no criminal records in India. You show up at the consulate and they will, once your interview is successful, they will issue to you what is called a immigrant travel visa. This is a sealed document that you receive, a sealed envelope. Essentially, this is your immigration documentation. They will cancel all your non-immigrant visas. So the next time you and your family members, when you travel to the US, will be processed into the United States as immigrants. Your passports will be stamped with a permanent residency stamp, and once you enter America, you will then thereafter apply for the green card and be issued the actual physical green card in the United States. This visa is valid for 6 months. So from the date of your consulate, when you get this visa, you have 6 months to travel and enter the US as an immigrant. So all in, from the time that you get approved to the time that the NVC, from the time that the NVC fee bill is filed, it typically takes about 6 months to get an appointment at the consulate in India. And so expect that somewhere after this, from the time that you file the fee bill at the NVC, within the next 6 to 12 months, you will be in the US as a green card holder. Now, the green card that is issued at either via the adjustment of status or via the consulate process is a 2-year green card. What is typically referred to as a conditional green card, um, because this carries with it the EB5 condition that within the next 2 years you will prove that your investment that you have made has created the 10 jobs that are required for the qualification of the EB5 program. This can only be filed a minimum of 21 months after the EB5 the conditional green card is issued to you. Okay. Uh, this will obviously be filed for you in the United States. The current adjudication time of this application, which is popularly called the 829 application, is ranging between 12 to 18 months, at which point of time you will be issued your permanent green cards or your green cards, which will thereafter be for 10-year periods and go through normal documentation renewal just like any passports. At only when under the program, at the stage of the filing of your 829 application is the earliest that you can withdraw your investment from the project or from the investment that you have made. So till such time as your 829 is filed, you have to remain invested under an investment that is qualified under the EB5 program. Okay. Once the permanent green cards are issued, all your family members are independent green cards. You are thereafter 5 years thereafter from the first date, which is the conditional green card is issued to you. 5 years from then, you will be eligible to apply for the US passports, provided that you've met the residency requirements that are required for anyone to qualify for naturalization in America, which means that for the majority of the year, you should have lived in the United States. Okay. We are going to revisit this process and timeline once we get into the issues that are faced by Indians to understand where the backlogging for Indian and the implication of that backlogging is for most of the Indian families. Okay. Um, so when you talk about EB5, right, what is a typical structure of an EB5 investment? Now, mostly we are talking about our project investments that are sponsored under the regional center. Now, what is a regional center? A regional center is essentially an entity, a private entity, or it may, in few cases in history, there have been joint ventures with some state governments or agencies, primarily private entities that are approved by US migration for sponsoring of an investment under the EB5 program. Their jobs are to do with compliances and meeting of the requirements and the reporting to USCIS about the underlying project. Now, the way EB5 projects are typically structured, okay, is that you see on the right, there is on the diagram, there is the project, the EB5 project. That's the underlying investment that you make. The most important thing for people to know is that when you make an investment into an EB5 under the EB5 program, your investment is going into a particular project. That project is qualified under the EB5 program. A regional center is merely sponsoring its qualification of the EB5 program. The underlying, what is the most important aspect of your investment is the project, because it is the project that has to thereafter be successful, create the jobs on your behalf, and return your money. Typical EB5 investment, where an investment company is set up, which in EB5 terminology is referred to as a new commercial enterprise. This new commercial enterprise is where EB5 money is pooled together, or all investors put in their money. The investment company thereafter makes a loan to the project, This project is given a money which is then structured in either as a loan or a preferred equity, or depending on what the capital structure of the project is the security cover for this investment company. Your typical EB5 loan made to the project has for a tenure of 5 years, and thereafter has to be repaid back or continued or redeployed. Uh, the E the project, the jobs that are created as a result of the projects are the jobs that qualify for the EB5 investors as the EB5 jobs. Now, the investment company typically has a manager which is responsible for the management and administration of the EB5 investment company. The manager may be the regional center itself or may be a third party, depending on the actual structure of the project. Typically, when you talk about what you see or hear in EB5, most of them will be the regional centers are coming and talking about themselves. The regional centers, past or present or future track record has no meaning on your EB5 decision making, because ultimately the project that you're investing into has to be successful. Because this, please understand, is not a bank. A regional center, it does not work like a pooling account for everybody, right? It is only putting in money for one project into one company and thereafter into that project. So it is not like when you put in money into a regional center, it can get spread out between different projects. It goes specifically into one project. Okay, and we will revisit this in terms of you know how that works for the new environment that we are seeing. So EB5 has been really, really successful in India over the last 5 years. We started doing EB5 in India in 2013. That year, there were about 30 Indian investors that went into the program. In 2018, that number has grown to over 1100. There has been a significant jump in the number of Indians that are using the EB5 program. And the reasons are pretty easy to understand. As it becomes more and more challenging for people to get H1B visas in the US, or for the H1B visa holders in the US to get into or get to the green card stage, the EB5 has offered a much faster track and opportunity for people to get US green card for themselves and their families, in terms of the timelines. But the success of EB5 is over time has led to the tripping of EB5 as an opportunity for Indians. We've seen this happen in China, we've seen this happen in Vietnam, and now we're seeing this happen in India. And the primary reason for this is that while there is no cap on the number of EB5 applications that are filed, there is a cap on the number of visas or green cards that are issued under the EB5 program for people from a particular country. Now, what is that cap? That cap in the US right now is 7%. The EB5 is 10,000 visas, and not more than 7% of them can be issued, or 700 can be issued to people from one particular country. The US migration follows country of birth, not passport. Therefore, if you're an Indian born, irrespective of what passport you hold or where you reside, you will be considered an Indian applicant. In April of 2018, at a conference in Washington DC, so over a year ago, it was announced by the National Visa Center that India is going to face visa backlog. And it was announced in April of 2018 that the visa backlogging for Indians will come in June or July of 2019. Now, how do they know this 1 year in advance? Well, it's simple mathematics. The number of applications that are filed by Indian origin families or applicants, they take an average number of visas per application, and they estimate the number of visa applications that they foresee coming from Indian applications under EB5. That number, when you divide by 700, gives you the approximate number of years it will take for people to get their green card turn. So as of 2017, when we had 580 odd applications of Indian origin, an Indian application is usually about 2.5 visas per application. That already meant that there is a backlog of 1,500 odd visas that are going to come up, and therefore the window was going to take over 2 years. This number by April of 2018 had gone up to a maximum of 5 years. And so, for anyone that has applied on or after April of 2018, it is important to have factored in that their expected timeline for getting to the next stage, which is getting the conditional green card, is going to be somewhere in the 3 to 5 years timeline from their date of application. Now, this has impacts on various other aspects of the application, which we will get into. So as of April 2018, it was announced that that the Indians filing in April 2018 and onward should expect a delay in issuance of green card. That is, even after the EB5 application is approved, there are going to be a delay in the next step, which is filing either for adjustment of status or for the National Visa Center for a consulate input. Now, this delay came into effect, or it finally went into backlog on 1st of July 2019, which means that as of in May of 2019, it was announced that the expected backlog for Indians is now going to be a maximum of 8 years, which means that there is going to be a maximum time between filing your application and getting the green card in your hand of almost 8 years. Now, for most of the Indians that are filed after April 2018, when this was already announced in the market, and when it came into effect in July 1st of 2019, please go back and check whether this has any impact on the application and therefore the visa issuance, especially for your children. Okay. So what we're going to do now is go back into this slide, okay, which is understanding the steps and what this backlog means. So getting into the first part of it, which is filing an application and adjudication of an application. The timeline still remains to be 18 to 24 months, right? So remember, I talked about what is called a priority date, right? The date of filing of your application. This is the most important date for you as you go forward, okay? Once your application is approved, a backlog country means that you will not be able to file the adjustment of status or consular processing at the National Visa Center till such time as the date of your application is not made current by US migration. Okay, the date that is current under US migration, and you can check this by just going to what is called the USCIS Visa Bulletin for September 2019. Right now, the date is 1st of September 2017, which means only those applications that were filed on or before September 1st, 2017 are now eligible to apply for the conditional green card stage, either via adjustment of status or consulate processing. Now understand that while this date may seem very close to you, that this is only 2 years, understand that the movement of this date now going forward is going to be very slow, because the bulk of the Indian applications that are pending or are filed are between 1st of September 2017 and where we sit today. So there are almost 2,000 applications, or 1,500, about a little less than 2,000 applications that are filed after 1st of September 2017 and this as we sit today. These are all going to come up for visas sometime before anyone who files today. And therefore, we expect a backlog for your turn to come to get a green card to be somewhere in the 5 to 7 year category if you were to file today. Okay. Now, what does this mean for someone who has already filed? If you have filed after September 1st, 2017, even if you're approved, you are not able to apply for the next stage. Now, this has an implication on what is called aging out of children. Now, remember that the EB5 application can be filed to include dependents or children that are 21 or below at the time of filing of your application. But understand that they also need to be 21 or below at the time when you file for the adjustment of status or consulate process. Now, US migration has something called the Child Protection Act, which allows that you minus or deduct the adjudication time of an application from the age of your child. So let's say you filed your application, it took you 24 months to get approval. And therefore, as long as your next step, which is adjustment of status or counselor processing, can be filed before your child turns 23, your child will still be included in the application. Otherwise, they will get aged out. Now, let's take an example. Okay, we talk about, let's say you were filed prior somewhere after September 1st, 2017 until today, and your child was 18 years old. Okay, and your adjudication is going to come in 2 years. So that child is going to be 20. So that means your child is covered till 23. Now, let's say your visa turn does not come for 6 years. Then your child will become 18 plus 6 or 24 and would have crossed that 23-year-old threshold. Okay, and will therefore not be included when you file for the counselor processing. For a lot of families that are filed specifically after April 2018, when this was first announced, till it came into effect, if this has not been factored in, if your immigration attorneys or the projects have not informed you about the impending backlog that has already come into effect, because it was in effect in April 2018, it was announced to be that it will be applied in June or July of 2019. You need to go back and recalibrate whether your children can be included or will get included or not get included in this application, and take steps to to correct any if your children are aging out. Okay, now the I've explained the backlog, we've explained the aging out. Now let's talk a little bit about what happens to your 829 filing, right, which is also going to get delayed. Okay, because remember, the 829 filing can only happen 21 months after your initial green card is issued. Now, obviously, if your green card only comes 5 years from now, your 829 filing goes back another couple of years, right? So your 829 filing will now happen in the seventh year. Now, your initial project investment might just be for 5 years. What happens to your money once that first project investment comes back? It still needs to be kept in an investment that is qualified under the EB5 program. This phenomena is called redeployment. Redeployment is one of the big factors that Indians need to be careful about, because most of the projects have not defined it, and this is a blind risk that EB5 investors are taking today. Because while the first project might be a beautiful hotel in a nice city or might be a very nice project, but once this money comes back, who controls where it goes next? This is where the role of the manager of your money comes in, and this is where conflicts of interest come in. So in a lot of cases with large regional centers today, we are already seeing issues that the Chinese are facing or have faced, where redeployment of money, where their monies have been further invested into projects that don't really meet risk standards that are actually safe enough for people, or their monies are just stuck. So for most of the people that are doing EB5, clear visibility and transparency over redeployment is key. Now, please understand that this is where when we get into the next part about selection of a project, is a very important fact is, and we'll get into how to choose something which is transparent, okay, and how to understand these issues. So let's get back a little bit into the typical structure to understand these risks, right? Remember that the investment companies, where you put in the money, the investment company puts it into the project, there is a manager and a regional. The investment company is a private company in the US. Project is typically a private project in the US. Regional center is a private company in the US, and manager is a private company. What are the transparency laws in America for private companies? Well, there aren't any. There is no disclosure requirements for private entities in the US, and there is no visibility over how your money is going to get redeployed. Unfortunately, the United States Citizenship and Immigration Services and the Department of Homeland Security have not prescribed a redeployment policy, right? So it is a blind risk. It is coming under the control of the manager in the regional center. You want to be with a manager or a regional center which has compliance requirements, which has transparency requirements, not someone who's just private. That's like giving money to a private developer in India or to anywhere, I mean, and having absolutely no control over your money. Okay. We will then, after this, come into examples of projects that we believe and why we believe these projects qualify and are well structured. uh, for the EB5 program. But before we get into that, let's talk a little bit about two of the issues that were brought up earlier. One of them is the change in the policy that has been announced by the Department of Homeland Security coming into effect on 21st of November. And the other is this removal of visa caps, where the bill was passed by the House, but is still pending at the Senate and is still not cleared yet, and what that means on the EB5 application process. Okay. Uh, so the first part, which is the Department of Homeland Security, is really addressed, coming back to the program, two aspects of this that they thought was detriment or was not being followed very well. One of them was the minimum investment amount, right? The DHS's outlook is that the investment amount has remained where it is for many years, in decades, therefore does not reflect any increase or inflation or indexation of the value of $500,000. And they have reset this value to be $900,000 in what is called a targeted employment area and $1.8 million in non-targeted employment areas. Now, and then thereafter have come in for indexation and how this is going to change as we move forward. Okay. Now, but what is more critical in what they have done is they have very become very tight about what is a targeted employment area. Remember that the targeted employment area was defined by each state, essentially was a census tract that had an unemployment rate which was 1.5 times or more of the national average. And what EB5 said was that it needs to be in or close to or connected to a targeted employment area. This was an aspect that was being used by the large EB5 developers or projects as they qualified mainstream tier 1 cities in the United States for EB5. They took a targeted employment area that was somewhere and they connected it to census tracts to arrive at the project location and qualified that entire thing as a targeted employment area. Typically, this was referred to as gerrymandering. Um, and essentially, the largest link between what is a targeted employment area and where the actual project was located was 100 census tracts. Okay, the DHS took upon this, and rightfully so, a very dim view, and said, well, that doesn't seem to be in the spirit of the EB5 program, where they say targeted employment area or a rural area, and they want you to be in one of them, and said in the new TEA that it has to be in a targeted employment area or adjacent to it, or border adjacent to a targeted employment area, and they will qualify targeted employment. Essentially, this disqualifies almost more than 99% of the EB5 projects that are available because they're all not going to qualify under the new definitions of targeted employment. November 21st has been set as the date, and they have allowed the grandfathering of all projects and investors before November 21st under the old program. So they gave a runway time for people to try to get to where they are, uh, and to try to raise as much money or invest in under the current program before the new rules come into effect. So as of today, we have another 60 to 90 days before the 60, 70 days, 75 days before this comes into effect. Anyone who invests today under the 500,000 program will be treated as an applicant under the $500,000 program and will be qualified under the current rules. So there is a last window of opportunity for all investors to get in at the current level before this investment amount is changed. Now let's just talk about the removal of the visa caps and the implication of that, right? Uh, the cap removal of 7% will lead to obviously the opening up of visas for people on a first come first serve basis. This is going to be a step up process if this rule comes or if this law comes into effect, and will benefit countries like India, which do not have a very long line, but will initially not benefit countries like India that don't have a long line, because the visas will then be allocated based on the priority date of individual applications on a first in first out basis. Now remember that the Chinese have tens of thousands of applications that are already filed and pending, and the Chinese waiting time for a conditional green card today is over 15 years. So all the Chinese applications that are pending from 2014, 15, 16, 17, 18 will get this visa before you get it. So the default backlog for most countries, for every country in the world, when this gets removed, will be at least about 5 years. Because the first 5 years, the 10,000 visas will get consumed by all of those that are already filed and waiting. So even the Indians that are filed in 2018 and 2019 that are backlogged could see potentially a same backlog time, or maybe a tad longer or shorter, depending on how many Chinese come in and actually consume visas, okay, during that time. Okay, so this brings us to the final part of our webinar today, which is selecting an EB5 project and what makes a good EB5 project. One of the big fears that we have as a company doing this in the last 5 6 years, and having seen EB5 so closely, we've entered into joint ventures with a company in Hong Kong, which have been doing EB5 since it started in 1990s. And so collectively, we've seen now projects over 20 years, and I've seen the experience of EB5 over 20 years. Um, is that today, with the coming changes, there are three major risks that EB5 investors will face. One, most of the EB5 projects out there, the EB5 investment is not in a first position mortgage, which means that the moment you're not in a first position as a security holder or as a cash flow recipient, essentially you're second or third. Second or third to a bank means you can essentially be wiped out if push comes to shove, which is a very risky position for an EB5 investor to be in. We have traditionally only done projects where we have first position mortgages and we have clear visibility over the title of the EB5 investment, as well as the receipt of cash flows of a project. Anything that is second or third position, no matter how second or how third, is behind the first and is too much of a risk for an EB5 investor. The second risk is redeployment. Most, as I've said, the EB5 investments are private sector investments. There is absolutely no control that you will have as an EB5 investor over a redeployment of your investment. The third risk that you are facing today is, as some of these projects have a significant portion of their capital that was dependent on EB5, and there is a time bound that only till November 21st will they be able to grow EB5 under the 500 and the TEA, and most 99% of them will not qualify under the TEA and therefore go up to $1.8 million category, will not, unlikely to see any new EB5 comes in. Therefore, there is a project financing risk that you're facing. Does the project have the ability to actually, cover the gap, right? If their EB5 raise falls short of what they expected it to be, and they're not able to raise the required EB5 by November 21st, a mere letter or a sort of confirmation or an assurance by a developer in the US saying that yes, we have the ability is not enough. You need to see the visibility and the actual confirmation and alternative sources that are available. Okay, most of the EB5 projects are already very thinly in terms of equity capital. Therefore, do they actually have the ability to increase more equity? And when I say ability, not just a letter from them saying yes, yes, I can, but the actual confirmation of how and where the money is and is coming from. Okay, so we as a company have been doing, as I said, EB5 for over 6 years now in India. And we've done many projects. We've got hundreds of people that are invested and shifted and are in the US under the program. Last year, with anticipation of backlog, we introduced a project that was offered a distinct advantage to Indians because it was expedited approved, where our families that were applied till September 2018 are all sitting in America on conditional green cards. In 2019, we introduced the only EB5 project, which is a publicly listed EB5 project. It is owned by a financial group based out of New York. It's an investment banking and financial management group, which is listed on the NASDAQ, is a multi-billion-dollar development. The advantages of being listed on the NASDAQ are that everything that they do is disclosed, is under the Securities and Exchange Commission regulations. It is the only EB5 project that we are aware of that has to compulsorily, quarter on quarter, report the EB5 fund loan administration, management, deployment, the sale, the revenues of their project to the Securities and Exchange Commission, to the NASDAQ, and you will be able to read about it online. You don't have to depend upon any private person in the US not picking up your phones or picking up your phones or trying to find them. This is available online on the SEC website and on NASDAQ, and obviously on the company's website because they have to disclose it. So we will show you a short video of this project and the main benefits of this project are that being publicly listed, it has the highest disclosure requirements and transparency available in EB5 for your investment. The redeployment of the money will remain within this group into phases of their projects, therefore giving you again 100% transparency of where your money can be, is going to be, will be, and how that money is being repaid. You are a first position mortgage holder. The owner of the project is essentially an investment banking group. There is no debt. There are only 15% of their total capital is EB5. The rest is being put in by the promoters themselves or by the developer and the partners themselves, which means there's a very low dependency on EB5, and there is ample credit lines available with the company as we sit today to fill the gaps that EB5 is going to, if EB5 raise is short of their expectation. This company has already done a successful EB5 project. We had $125 million raised, 250 applications, more than 100 have been approved to date. The rest are in processing. The previous EB5 project is almost built and is going to finish its sale. The EB5 money, if required to be moved, will be moved into the next phase within their group and will remain within an SEC, regulated entity. The next phase of the project is is underway right now, which is where the EB5 money is being raised for. And like I said, because the EB5 is a replacement capital for them, because they already have the credit lines available, they already have the financing in place for zero EB5. If they get less than what they had assumed, the EB5 raise will not in any way impact the project's ability to complete itself. We're going to show you a short video about this project as we go, and then we'll be open for question and answers for the audience.
San Diego, California. Beautiful beaches, exquisite golf courses, outstanding universities, and world-famous tourist attractions. With near-perfect weather, a wide range of outdoor activities, and a unique, relaxed atmosphere, it's no wonder San Diego has earned the moniker of America's finest city. HomeFed, a publicly traded real estate company based in San Diego, is pleased to offer EB5 investors an opportunity to partner in our next San Diego development project, Coda Vera. Coda Vera is a 300-acre master planned community located in South San Diego County within the larger master plan development of Otay Ranch. With a long history of success, Otay Ranch has been the best-selling development in the San Diego region for 20 years. The area has excellent schools, attractive housing, convenient shopping, and is only 15 miles from the jobs, entertainment, and nightlife of downtown San Diego. Coda Vera, the next master plan community in Otay Ranch, is planned for up to 2,379 homes, including single-family homes, townhomes, rental apartments, and senior living. The community plan also includes neighborhoods serving retail, office buildings, a new elementary school, as well as parks and a resort-style swim club. Grading commenced in 2018, and home building will begin in early 2020. A wide variety of homes will initially be priced from $400,000 to over $800,000 and will be built in partnership with premier national home builders. HomeFed's most recent EB5 project, the Village of Escaya, successfully attracted $125 million in EB5 funds, accommodating 250 investors. Ascaya, also in Otay Ranch, has been the best-selling community in the San Diego region. When complete, Ascaya will have 990 homes built in partnership with Brookfield, Lennar, and Shea Homes. The community will also include 270 apartments, shops and restaurants, parks, office space, and a new elementary school. EB5 clients were attracted to Ascaya's secure business plan, which provided them with a first trust deed and 15 jobs per investor. Building off this success, HomeFed is pleased to offer another exceptional EB5 opportunity. As with Ascaya, each Codavera investor is credited with 15 jobs and receives a first position trust deed, providing them the safest position in the capital stack. This deed of trust is recorded with the government and fully collateralized by HomeFed's additional development property. HomeFed is the largest residential developer in the San Diego region, with a long history of developing award-winning master-planned communities, including San Elijo Hills, a 2,000-acre development that was honored as National Master Plan Community of the Year in 2003. HomeFed has projects across the United States and specializes in land acquisition, obtaining government approvals, and constructing the infrastructure necessary for residential and commercial development. HomeFed is proud to take part in the EB5 program. Codavera's excellent location, conservative financial structure, and experienced sponsor provide EB5 participants a unique immigration opportunity and confidence in their financial investment.
Thank you, Pankaj, for that insightful presentation. I am sure it has cleared all the doubts and satisfied all the queries for anyone interested in the EB5 program. We will now open up the webinar for questions. I will request the participants to kindly type their questions in their chat boxes and I will put them up for Pankaj to answer. So Pankaj, we've got the first question for you. The participant wants to know, he says, I did my EB5 in January, but I was not told about retrogression. Can I seek legal help against my agent and project?
Hi. Well, thank you so much. And before I answer that question, I hope I've managed to clear doubts and not create doubts. Okay, because there are lots of technicalities and nuances that we talked about, which may create doubts more than clear them. Sorry. So, yes, thank you so much again for joining in. And to answer the specific question, that in January 2019, you have filed an application and you have not been informed about the announced retrogression that India is in for January 2019. Yes, there is recourses that you can take. We are happy to listen to you and advise you on what options you have. I think the challenge that you will face is that will the project, let's say this doesn't work for you anymore, right? Let's say you made the investment and this does not work for you anymore because your child is going to age out, or you needed the visa for a certain at a particular time and are not going to get it, and therefore will not be able to continue in the US, etc., or be in the US, etc. I think the challenge that you will face is that will the regional center of the project refund you, right? And I think there is a case to be made, because we've seen this in the past, where if you have not been informed, and more importantly, if you have asked and not been provided the right information, you have the legal recourse for it, and we are happy to assist you with it. We just request you to get in touch offline and with us, and we'd be more than happy to listen to what has happened and see what we can help you out with.
The next question, Pankaj, for you is, do you have a Gantt chart showing the typical timeline for the entire process to be completed from the application date?
Yes, we do. We can give you a sort of idea around it. Understand that these are mostly estimates that we will have to use. So if you, I don't know if I can pull it up again, but if you want an actual timeline, I can just quickly revisit it. Can I just give me 1 second, and I will just go back into the slide. This slide that we had shown you, right? So process starts, or when your documentation is filed to adjudication, is an 18 to 24 month cycle. Okay. Once you're approved, this is when you have to wait. Okay. Now remember that once your process starts, that is your priority date. So today, 11th of September 2019 is your priority date. Okay. The adjustment of status or counselor processing date is the date that is published by the National Visa Center, or sorry, the US Migration Department, under what is called the Visa Bulletin. I can show you quickly the current Visa Bulletin if you give me a second to change over the slide. Um, so this is the latest Visa Bulletin. Okay, as you can see, the Visa Bulletin. This is chart B. But essentially, the current visa bulletin, if you would just Google USCIS visa bulletin September 2019, you can pull it up. The date over there is 1st of September 2017. Now, there are two charts in this, and this is a very important thing that I think let me address, because I think we missed it in our presentation. So thank you for bringing up the dates. There are two charts in the visa bulletin. There's chart A and chart B for the employment category. Chart A has the dates for which the visa priority date is current and prior, which means that anyone who's filed on or before that date is able to apply for the adjustments of status or the consular processing. Chart B is for adjustment of status. Okay. Now, typically chart B follows chart A, which means that if you are in the US or outside the US, you can only apply for consular processing or adjustment of status if your priority date is on or before the date on that chart and you've been approved, obviously. Now, every year at their discretion, USCIS allows the adjustment of status to be filed out of turn. So they open up chart B for adjustment of status filing for a short window of time, where people, those that are in America, are able to apply for the AOS. They will get the EAD card, but their green card will still take the same time as the original list will take. Okay, so quickly going back to that chart that we had. So like I said, once you're approved, you have to wait for that priority date to become available on the visa bulletin. So if you're in India and you file it, you will have to wait for it for consular processing. So you will have to wait for about 5 to 7 years today before that consular processing happens, irrespective of how long it takes to actually get the approval of your application. So whether you get approved in 2 days or you get approved in 2 years, you will still have to wait for 5 years to 7 years for that date to come for you to qualify for the appointment at the embassy. Now, like I said, on chart B, at their discretion, they might open up the adjustment of status filing. They've done it in 3 out of the last 4 years. It's typically in, when the visa year starts in October or November. It will give you the EAD card, which I had explained was step 1 of the adjustment of status filing, which allows you to work and travel internationally. But your green card will still come at the same time as that of a consular processing from India. Okay. So you will get an EAD card, the EAD cards for 1 year at a time, and this will get renewed until you get your green card. I'm happy to, if you guys want more information on it, I'm happy to, if you can connect with us, you can provide information on this.
Sure, Pankaj. Thank you so much for that answer. And dear participants, that's all we have time for. We hope this session was worth your time and will help you in approaching the EB5 program in a much better way. I would like to thank Pankaj for those wonderful inputs and to all of you for sparing time for this session. Thank you very much and have a wonderful evening ahead.